Rebuttal.
3?
Yes.
Thank
This
you.
is
Go right
in,
ahead.
this is in regards to Curtis Keller, who has multiple matters before this court being heard in this appeal. He has a petition or a motion for DNA post-conviction that was denied, a motion for new post-conviction, which was denied, writ of error quorum nobis, which was denied, and a motion to correct illegal sentence, which was denied. So focusing first on the request for DNA post-conviction. This is a matter that was set by the trial court, and prior to it being set for a hearing, the trial court gave deadlines for if the state was going to file any motions, if they were going to dispute its validity, anything of that nature. It was some, believe the record, it's in the transcript, I believe it was February 22nd or 23rd of 2023, I believe, somewhere in that range. But there was a time period for the objection to be filed, if any, or any motions, and then if not, the hearing would be heard on April 10th, less than a few months after that. The matter was set for a hearing, then set from the morning docket to the afternoon docket to be heard, and then prior to putting a witness on the stand, we had an expert that was retained and putting in testimony. The court then dismissed the matter under the position that it was not required to have this matter heard because the crime charge was not one of the crimes listed in which the appellant would have been entitled to a DNA post-conviction.
Was the defendant convicted of an offense that would qualify?
No, I agree that it did not qualify. The only contention we're saying is that after the matter was set for a hearing, after previously being set for the state to file any objections, then from that morning be held to the afternoon, and then right before calling the witness to testify, at that point dismissing it, we would say in that scenario, it's an abuse of discretion, specifically in relates to the case law, which states that in making its decision on the DNA petition, the post-conviction court must consider all the available evidence, including the evidence presented at trial and any stipulations of fact made by either party. So our contention is, when you need to consider all the available evidence, we have an expert at that point in time who is present in the court, who's been retained by the appellant. So in most of these scenarios, you're asking for a DNA post-conviction, and you have no...
Mr. Toon, I think you're putting the cart before the horse in a way. That's assuming that you filed properly under the act, and the court
Correct.
has to consider all these things.
Correct.
If the crime involved is not recognized under the statute, then, you know, your estoppel theory or whatever it is, that once this judge starts down this road, we have to have a hearing. If the statute doesn't allow for it, how does a judge have the authority to hear it?
Well-
Because again, this is one where there's a final judgment.
Right.
The only way the judge gets jurisdiction back is if this has been properly filed under the statute.
Correct. And so the issue is, and where I think we're using slightly different language. I'd prefer if we all adopted mine, but specifically it's that the court is not required to hear or to grant a DNA post-conviction. It can use its discretion. So to that point that you're making, I had no right, or the appellant had no right to say, you must hear this. Based on the charge or the crime that was alleged, the court then had discretion to hear it. However, it still could be heard, meaning the court's hands wasn't tied. It was not prohibited from hearing it. It just could use its discretion whether to hear it. What happened on April 10th is the court says, well, hey, I'm elected not to use my discretion. So I'm not saying the court didn't have discretion. What I'm saying is that the court did use its discretion when it said, if you're going to file any motions to dismiss or any issues, state you have until this date in February to do it. And if you don't, we're having a hearing April 10th. They did none of those things. Therefore, the court used its discretion so we could have a hearing April 10th, which we were prepared to do, and then went from that morning to being held to the afternoon, and then went from that afternoon not calling the first witness to saying, never mind, you're not going to have a hearing at all. So it's our contention that the court could use its discretion. However, it did, and it granted the hearing that we were then prepared to have. And at that moment, we're suggesting that you can't just arbitrarily say, never mind, I changed my mind, based on nothing new, because it's the same charges, nothing changed that got us to that point. The only thing that changed is that the state never responded to filing any motion at the deadline given to the court that would have potentially prohibited a hearing to go forward. So we were operating under the court's ruling, and the court should have honored that. That's not fair to the appellate who's incurring these expenses and these fees based off of representations made by the court. We've done everything in compliance with the court, so the court then had authority to hear it, even if the court ultimately said, I now hear the proof and I'm electing not to grant it a DNA post-conviction. That doesn't change the fact that at that moment, I believe we did have a right to a hearing because the court did exercise its discretion in allowing us to have that hearing up until that point, and he was harmed. He would not have ever, as you can imagine, spent those expenses and put himself in a position, but for the fact that the court said, if state, I'm telling you now, if you don't do these things by this date, the hearing's going forward. And at no point in the transcript is this fact disputed. At no point is the court saying, or the state, Mr. Tootin, that's not what was said, or that's not. No one is disputing that that's the sequence of events and how it happened. The court is simply saying, well, I'm electing now not to exercise my discretion. So our position on the DNA post-conviction is pretty straightforward. We were ready, able to go, and we were set on the day. The court set it for hearing only after the court said, state, if there's any objections, do it by this date. If not, the hearing's going forward.
Let me ask you about a procedural question, just backing up a little bit. In the state's brief, in a footnote, they note that your notice of appeal was untimely. And I thought maybe we'd get a reply brief where you would maybe address that. So can you address that for us?
No, everything was timely. I did it in the sequence of events. We got the different orders. The last order I believe entered was May of 2023, and then we filed this. I mean, again, to the extent I will, out of abundance of caution, I could do a motion to accept a late notice of appeal, but from the deadlines from when the orders were entered. So this is another issue where.
Because this is a consolidated appeal from
Correct.
multiple
Correct.
issues, and I think orders were entered at different times on
Correct.
each of.
And the appellant, once he received the orders, we filed it within 30 days from there. So to make a long story short on that, we will also file a motion to accept a late notice just to clean that issue up and flesh it out. But this was filed when we received the orders. I believe I'll file the motion and flesh that out, and then the court can see it and do as it may. But it's our contention that it was timely, everything was timely presented to this court is our position. As it relates to the motion for new post-conviction, again, this is an area that I would implore this court to dig into, because this is not the first time I'm seeing issues like this where there's concerns that happen after someone's had a post-conviction hearing.
The statute says you're entitled to one.
Correct. But the issue is there's issues that never gets raised in the first post-conviction, because the reality of it is our position is it's part of the first post-conviction, but there's an issue that hadn't been raised or fleshed out. But what tends to happen is we say, as the defendant, hey, this is information we never had before or seen before, and so we'd like to revisit this post-conviction. And then the response is always, hey, it doesn't fall into one of these categories, and then it doesn't technically fall under writ of error. And so defendants are being denied an opportunity to come before the court when there is something that did in fact impact their post-conviction because the evidence and information wasn't available. And so really what we're arguing is we want to continue the first post-conviction with the option to add this information to it.
But it was concluded. So how many times can somebody file? The statute says one.
And that's what I'm imploring this court to consider. In this scenario.
We can't change the law. I mean,
Your Honor,
we really don't have much authority.
No, Your Honor, I think you
reviewing
do.
Body, and we can't change what the statute says.
And I'm not asking you to change the law. I'm asking you to interpret the law to mean that when you have one post-conviction.
Well, when the statute says you have one post-conviction, I think that's really clear.
But during your one post-conviction, if it's later determined that there's evidence that the defendant should have received but never had that, then that evidence can be considered as a part of his one post-conviction as a bifurcated matter.
I don't think there's any law that supports
I think
asking us to do that.
What I'm asking is to interpret the one post-conviction as being a bifurcated proceeding when this happens, because if you don't.
There's no precedent for that.
And that's
Agree with
why,
me on that?
as I believe
And that's not what the statute says.
I believe we're at the right place at the right time, that we're all here summoned together to carve this
I think you
path.
misinterpret our power or authority.
Because
So-
if we're not interpreting it that way, what'll end up happening, which has been happening, is evidence that the defendant is supposed to receive, he doesn't get, and then there's no remedy to address it. And that can't be what due process is saying, if not from the Tennessee level, at least from the United States constitutional level of due process and his right to be heard. It possibly can't mean that. And so what we have here provided to him in discovery, this is not something that was told to him. He finds out after the fact. And at this point, then where does he go? The scenario can't be that this type of behavior is being condoned. If the court believes that this occurred, there has to be a remedy. Well, his remedy is, to the extent that this is a Brady issue, the remedy says when you have a Brady violation, that has to be brought up in the post-conviction, where he didn't know it.
Let's stop for a second, because you're saying that the trial judge, and again, I think you're reading more into this than the record is, the trial judge was a prosecutor in the office at the time this defendant's case was pending.
Correct.
There is nothing that I saw raised that said that this particular prosecutor had anything to do with the case, which is what the judge ruled, that there's no showing, he's just one of the prosecutors, and there was no showing he worked on the case.
And again, that goes back to the concern. Once he uncovers this information, and it clearly wasn't provided to
But
him.
did he even present any information
Well-
contrary to that the prosecutor
Well-
was anything more than just a prosecutor in
well-
the office at the time?
But I think that goes to the concern I'm hoping we're all addressing in harmony. But it sounds like we might be reaching different conclusions, but we're not done yet. The issue would be, is once he discovered this information and it wasn't provided to him, that is what necessitates a hearing to determine, okay, what is the details in this? Because if not, then it could encourage, a ruling to the contrary could encourage the state to say, you know what, just don't provide all the evidence, see if they figure it out, and then if they figure it out, see if they can determine how to connect the dots
Mr.
without.
Tootin, I still think it's the petitioner's responsibility to frame the issue.
Okay.
Just to say, hey, we found out that this guy was one of 106 prosecutors in the office. It's a lot different than to come in and say, in your petition, we have evidence that he worked on the case.
Well, but again, once he finds that out, then the issue, I believe, is framed, because now there's a question as to whether any discovery violations, was this something the state was aware, which I would presume under this one, I couldn't imagine they weren't, but was this evidence ever provided to the defendant, and then how that impacts him? And if we don't do that, then what ends up happening is, and what I'm suggesting happening is, not only does this close the door to the defendant on the protection of his rights, but it also, whether intentionally or not, encourages the state to say, look, maybe we should have given them information or not, but the reality is we just got this ruling. We don't have to, because if we don't do it, they're going to then have to figure out how to connect the dots. So just don't give them anything and see what they can come up with. And if they can't connect the dots, we can have the courts rule for us. We don't have to say anything. I think the fact that it's discovered. Now, if it would have been concluded that he was mistaken and that this judge was not in the office, then I think that's different. But even in the order, the court is conceding he was in the office, and nowhere are they suggesting that the defendant knew that. And so the question becomes, what do we do with that information? He would have argued it at his post-conviction. The problem is he didn't have it. And so if that's not considered something to treat the post-conviction as bifurcated, and then the doors are just closed. And if that's going to be the ruling, I think maybe we just need a clear line drawn in the sand so that all litigants and defendants know going forward, if that happens to you, you're just stuck, because there's just no remedy available. Because if that's what it is because we didn't get these rulings that says from the court, this court particularly, that if there's an issue with a Brady violation, the proper form to address that is in post-conviction. Well, how can he address it?
What was the Brady violation?
Well, that's what the hearing is for. That information was not turned over or given to him, and the question
Wait,
becomes,
What was the Brady violation?
our contention would be that would be a Brady violation, not turning over to the defendant information that says that the judge who's hearing your case right now was the prosecutor in this case, and we don't know, or
Who was the defense attorney?
for my client, I don't want to mistake, I'm not sure. There were multiple different ones, and I don't want to name the wrong one.
And you're saying
I believe it was.
none of these lawyers knew that Judge Carter was a prosecutor before he became a judge?
From my understanding, that's what I'm saying.
I know that's what you're saying.
But my concern is, to the extent there is a concern, because I think this is a concern, it needs to be a hearing, because if not, this type of behavior, I don't think any of us are saying this is good behavior, good practice, or acceptable. But when you have one ruling from this court that consistently says where you address potential Brady violations as a post-conviction, but then when we come to try to do it as a new post-conviction, we're saying that's not the actual form. There has to be, so again, I'm interpreting this court to have the power to say, on one hand, we're telling them to address it in a post-conviction, and then on the other hand, we're saying it's too late because you already had a post-conviction where you didn't have that information. Surely there's a way to merge those two and say, we conclude then the only logical thing to do is to call it a bifurcated post-conviction hearing. And that's what we're asking. And then the last issue, which again is fleshed out, the writ of error quorum nobis, that writ of error was filed on 2 different case numbers. The court only ruled on 1 anyway, so we'd ask to be remanded back. I think opposing counsel argues that I only relied on 1 and there's nothing in the record for 2. That's not correct. It was both. It's on, I believe it was page 9 of volume 1. But it clearly asserted under my supplemental that it was going under both writ of errors. But that writ of error actually included a very detailed affidavit from the expert. That was not addressed by the court at all in its denial. The court did not rely or review that affidavit at all. So it was not properly dismissed, if nothing else, because it didn't dismiss it on both cases, and it didn't review the actual affidavit, which was the heart of the basis as to why we had new evidence. And then the last issue, which I was always going to touch on briefly, the motion to correct an illegal sentence.
What was illegal about the sentence?
There was concerns about the pre-sentence report that stated that there were no enhancement factors filed by the state. And basically, the argument on the motion to correct an illegal sentence is that it was done pro se, the order was done without me being involved in that. But when there's concerns with the pre-sentence report, and the pre-sentence report is a material document for the court to consider, it opens the question, should we have relied on the
How is it a legal
sentence?
sentence? That's what I'm trying to figure out, is how is it a legal sentence?
And my position to that would be, there's a question now as to how legal the sentence was when you're relying on documents that are faulty. And again, that's something that we would need a hearing on,
Well,
because
no,
as we
no,
sit
no,
here.
no, wait a minute, you have to establish that the sentence was illegal based on the judgment, and you haven't indicated to me.
No.
What was filed was something about, well, the enhancement, the state filed a late notice of enhancement.
Mm-hmm.
And that's not required under the sentencing statute.
Yes.
It's a question of whether or not the state filed a range 2 notice timely, which apparently they did.
Correct.
Notice of enhancement, the state doesn't even have to file that. That's just what the court has to consider that.
Yes,
So how
and-
is this illegal?
Well, because, and again, it's step by step, that gets there. We're saying the sentence was based on the pre-sentence report in part, and the pre-sentence report is faulty. Therefore, if the pre-sentence report is not accurate, then anything that you base or derive from that would be similar to an argument of a fruit of a poisonous tree. So that's where that becomes illegal, and because it's the byproduct of something that on its foundation was faulty to begin with.
Okay.
Thank you.
All right, General Coleman, good morning again to you. This is just your second.
Good afternoon.
Is it afternoon?
Your
It
Honors.
is. Good afternoon.
Ronald Coleman on behalf of the state. I recognize that I am the only thing keeping you all from lunch, so I will try to be as brief and concise as I can.
That's an excellent game plan for you.
Thank you. This case does have a significantly long procedural history. I think I've spelled that out in my brief, and hopefully it helped make clear of it. This is a bit of a shotgun approach by the petitioner. There are 4 different procedural avenues he has sought, and I'll take them one by one. So first, the petitioner complains that the post-conviction court denied his petition for DNA analysis related to both cases. And there are 2 separate omnibus cases that are at issue here. So he filed a petition for post-conviction DNA analysis on both, didn't really specify exactly what he wanted to test, instead raised sort of allegations of due process and Brady violations. And the defendant seems to really be putting a lot of emphasis on the fact that at some point the trial court set a hearing for this motion. And that is not the be-all, end-all. That, in fact, doesn't really matter at all. It doesn't, that is not the court's exercise of discretion. Instead, what the court has to do is review this when a petition for DNA analysis is filed. To your question, Judge Campbell, how does the judge have authority to hear this? So if it is an enumerated conviction, the court has to consider it. But there is a provision in the statute that says the court, for other offenses, has the discretion to kind of look at it. So the court acknowledges this. It's both in its order, and that's on page 45 of the technical record, and at the hearing. I think the petitioner has alleged that the court sort of made this arbitrary finding of I'm just going to do this with no new information. The hearing doesn't flesh that out. At that hearing, the post-conviction court explained this isn't one of the enumerated offenses. The petitioner responded, yes, but you have the discretion to do that. And the post-conviction court said, I don't want to use it. I don't want to use my discretion. And it emphasized the jurors ultimately made determinations about his guilt or innocence. Most of the proof, quote, was not DNA related. That's why it didn't exercise its discretion, because this DNA wouldn't have changed anything, so there's no point in moving forward. That was a proper exercise of discretion to the extent that this court wants to waive the untimely notice of appeal with that. And again, the state does submit that that was an untimely notice of appeal. It was a proper exercise of discretion. Turning to the next claim, which is, I'm not entirely sure, it's labeled as a quote-unquote new post-conviction. That's not a thing. The statute very clearly and very explicitly says you only get one post-conviction petition. The petitioner tries to frame this now as sort of a bifurcated proceeding or a continuation. The statute's very explicitly, the legislature has contemplated this, and they have provided a statute for how you can make this a bifurcated proceeding or how you can continue your post-conviction proceedings. That's a petition to reopen. That's to the extent that that is what this motion for a new post-conviction constitutes. The petitioner hasn't met any of the factors listed for why reopening would be appropriate, and to that extent, he also hasn't perfected his appeal with that. You have to file an application for permission to appeal the denial of petition to reopen. He didn't do that here. You should dismiss it for that reason alone. To the extent that there's sort of this other thing, of just a separate post-conviction that is statutorily prohibited, this court is bound by the statutes that this legislature does, and the trial court properly dismissed that. If there aren't any questions about that, and I will briefly mention that there is just no Brady violation here. The complaint is about something that happened at the post-conviction hearing. Brady relates to the trial, and even if it were true what the petitioner complains about, judges are allowed to be prosecutors before they become judges. There's no conflict there. There is no issue there. Turning over to the quorum nobis petition, technical record, pages 10 to 19, encompass the petition for writ of error quorum nobis. It explicitly lists one of the two cases. The record says that this was filed for one of the two cases. The trial court couldn't rule on the other one because there was no other one, at least what is in the record. And with that, the trial court properly dismissed it for a couple of different reasons. One, it's untimely and the petitioner didn't establish that tolling was appropriate. And two, because the petitioner has waived the claim that he is raised on appeal. He is now complaining about this affidavit and this examination about a TBI expert or the TBI analyst. It's important to note that on page 15 of the technical record, his quorum nobis petition claimed that quote, the newly discovered evidence in this case is enter of database buccal swab numbers such and such. That's not what he's complaining about on appeal. He has waived what he's claiming about on appeal. The trial court properly dismissed the petition for writ of error quorum nobis, and this court should affirm that. And lastly, I will go to the motion to correct an illegal sentence, which I will say is the only matter that is procedurally properly before this court. The petitioner did file a timely notice of appeal from that case, but he hasn't stated a colorable claim. To the extent, today I believe the petitioner has referenced a lot about the pre-sentence report. That was not what was complained about in his motion to correct a legal sentence, so that is waived. Instead, what he complained about was the failure of the state to timely file a pretrial notice of enhancement factors. At best, that makes his judgment voidable, not void, which means it's not an illegal sentence. So the trial court properly dismissed that motion too.
Is the state required to file a notice of enhancement?
State's not at all. I believe there is case law that If it's not, it might affect how the trial court can sentence it, but when you're looking at it post-finality of judgment, it doesn't affect the validity of that. It does not render the judgment void, and for that reason, it's not an illegal sentence. If this court doesn't have any questions, we respectfully ask that this court either dismiss the appeals or affirm the denial of relief in all of these different procedural aspects. Thank you.
All right, thank you, General Coleman.
Yes, we don't, again, in behalf of the appellant, we don't agree that the appellant is taking the shotgun approach, but what we will say is the appellant would like a fair shot. So similar phrasing, but slightly different. What we're asking for in this case is just to have this court step in and assist. So again, going back to the timeliness, I have to reiterate, in the writ of error coram nobis, there's only an order entered under one case. He has 2 cases before the court. So to the question, there's timeliness, even as we sit here today, there's never been an order entered on both cases. And
Was the petition filed in both cases?
yes, well, there's is volume 1, page 9. There's a supplemental writ of error that incorporates everything and has it for both cases, which includes the affidavit of the expert. So if you're even arguing timeliness issues, this case is still pending with these issues before, presumably the trial court. There might be a question of jurisdiction.
We don't have jurisdiction.
That's what I'm saying. There might even be a question of jurisdiction because it's under these cases. So again, even in arguing the timeliness of the appeals, you still have an issue where the court hasn't ruled on everything and it's still questions of what's outstanding. And then as it relates to the application to reopen and things of that nature, let's keep in mind this case was an unopposed motion to consolidate everything to be heard at once. So if that was not agreed to, there would have been a separate track to argue these different things. The reason we're hearing it all together now is because I think both parties agreed and the court ultimately concluded through its order. It just made the most sense to do it this way. So again, that also goes towards whether there's any genuine concern about timeliness. But again, the writ of error is clear that there's an affidavit that the judge, if you read the ruling, never addresses this expert at all. It is extremely obvious. She never reviewed it. So you can't say that there was nothing properly before the court. And again, going back to this motion to reopen post-conviction or however we want to label it, I guess the question the appellant is posing to us, this court, is if in one hand there's law that says when there's a Brady issue or violation, you have to address that in a post-conviction. You have to. And you have a scenario where that information wasn't available at the post-conviction, the appellant is at least asking for clarity. What do you do under that fact pattern? Because in the other issue we're running into is we're told you only get one post-conviction, and those statements, as our position, appears to at least be in conflict with each other. And then as at least it relates to Judge Campbell, I can say that from the time practice in front of you, there was literally never a time where you didn't go before a defendant when you looked at the case. I guess you could take judicial notice. If you said, you looked and said, wait a minute, I was in the office at that time, sir, you need to be made aware. Like, that was routine. Literally never a time that didn't happen. So when that information is not provided, it's a concern. And the reason you were so cautious to do it is because it was a concern. Thank you.
All right, thank you. Court will be in recess until 1:30.
All right.